Hello and welcome to Muckle's annual employment law update for 2014. I'm Frances Cameron and I'm going to be presenting the first half of this session. Tim Davies is going to take over for the second half. These slides are going to cover the main changes that have happened to employment law and employment legislation over the last 12 months. I have to say, when starting preparing for this presentation, I was surprised to see how little new legislation had come out this year. In actual fact, what we're seeing is more the effects of things that had changed last year. In particular, on this first slide, I've just covered the main change to the tribunal system. On the 29th of July 2013, employment tribunal fees were introduced. You might recall there's a Type A claim and a Type B claim, and now there are fees that are charged of the claimant or the employee in order to bring the claim against the employer. So in a Type A claim, which are the less serious claims, they have to pay £160 to be able to issue their claim. In a Type B claim, which covers unfair dismissal, discrimination, whistleblowing, and the more serious types of claim, they have to pay £250 to issue the claim. And then in addition to that, there is a hearing fee once they get to the hearing. As a result of this, there has been a dramatic reduction in the number of tribunal claims that we're seeing being brought by ex-employees and existing employees. In particular, you'll see the statistics at the bottom of this slide. There's been an overall 70% reduction in the number of claims nationally. And in Newcastle Employment Tribunal in August 2014, there are only 58 single claims filed. That's compared to several hundred of claims that used to be filed per month only 12 months ago. So that's been a big change to the way that the tribunal system operates. But in addition to that, for those of you that have been to our training before, you'll remember that I talked last year about the mandatory early conciliation procedures that were introduced. These were introduced from the 6th of May 2014, and they're essentially a compulsory procedure that the claimant or employee has to go through before they're able to file a claim against their employer. It's via ACAS, and as a result, we're hearing that ACAS are currently inundated with a number of employees calling them to talk about mandatory conciliation and discussing with ACAS whether they have a claim against their employer. This is also reducing the number of tribunal claims that we're seeing coming through, and the reason for that is that ACAS is now having the opportunity to intervene at that very early stage and either get a settlement agreed between the two parties or acting as a neutral body, perhaps suggesting to one party or the other that either there is a decent claim that needs to be paid off or that the employee's claim may be considered vexatious if it goes any further. Now, ACAS are actually not legal advisors. They're meant to act as neutral, a neutral or independent party in the process, but you do find that they are able to give quite a good steer at the early stages as to whether there would be any merit in taking that claim any further. So overall, the main point to note is that there has been a huge reduction in the number of tribunal claims being brought, which is good news for employers. I should mention, though, that the Labour Party has stated at the TUC conference earlier this year that if they are elected next year into government, then they will be changing the tribunal fee system. So there could be changes in future. Now, I don't think they'll remove the fee system altogether, but they may reduce the fees to try and give more access to justice. Moving on to the next slide, some of the other changes that have come through this last year. Firstly, you may be familiar with the fact that flexible working requests have been extended beyond employees with caring responsibilities for children and disabled people. Now any employee can make a flexible working request provided they have 26 weeks service. We've also no longer got the statutory prescriptive procedure for making the flexible working request, and instead it's now given in guidance. I have to say, though, much of the guidance is very similar to what we already had in the statutory procedure about holding a hearing, offering a right of appeal, etc. And indeed, the same 8 grounds for refusal apply, so the employer must still rely on the same 8 grounds. It is worth looking at your handbook or your policies to check that they're up to date. I suspect, if anything, they may go beyond what is now required because your policies are more likely to be based on the original prescriptive and statutory procedure. Just moving down to the bottom of this slide, shared parental leave is a new concept that's going to be introduced for births after the 5th of April 2015. Shared parental leave is probably a slightly confusing name because it makes people think about the current parental leave provisions. This is actually the sharing of maternity leave. So although a woman will still have to have the 2 weeks compulsory maternity leave immediately after the birth, she will in future be able to share the remainder 50 weeks leave with her partner, husband, civil partner, and so you could in future have the two parents sharing the 50 weeks leave between them. You could have, for example, mum going off for 5 months, then dad going off for a few months. Or you could indeed have them both going off at the same time. If they go off at the same time, they cannot have more in total than the 50 weeks leave between them. So what in fact it does is curtail the amount of leave that they have. So they could both have 25 weeks off at the same time, but they would have to come back to work effectively after 6 months. The same concept will apply to the statutory maternity pay. That can now be shared between the two parents depending on who's off at which time. It's not the 2 weeks immediately around the birth because, as I said, the compulsory maternity leave still applies because the concept there is about allowing the mother who's delivered the baby to recover, but it's the additional 37 weeks statutory maternity pay will be sort of shared between the two parents. The main impact of this is that I think there'll be a big impact on small employers, particularly those that may be employing both the mum and the dad, or perhaps the two mums if it's a single-sex relationship. And those sorts of employers are going to really be impacted by this, and I think until we start to see these sorts of relationships coming through, it's quite difficult to know how employers will react and whether the government will have to stand in. The initial feedback is that most employment lawyers and indeed the government think that there won't be a huge take-up on the shared parental leave, and I think this is simply because the additional paternity leave that is currently in place hasn't had a huge take-up. Most employers, most of our clients are saying that they've not had many requests for the additional paternity leave. I should mention that the additional paternity leave is going to be removed because this concept of shared parental leave is going to take place or take precedence over that. And the other point that's slightly quirky is you may recall that a lady on maternity leave, if she's put at risk of redundancy, is entitled to suitable alternative employment, so she's entitled to be offered the vacancies over and above other employees. That concept is going to also apply to the other partner on shared parental leave, so perhaps the man. So it's just to bear in mind that the concept of suitable alternative employment being offered in a redundancy situation to those on maternity leave over other employees is going to also apply to the other partner who's on shared parental leave, whether that's a man or a woman. Just moving on to the next slide and final slide on family-friendly policies. The other change that's just recently happened on the 1st of October is that the time off for antenatal appointments has been extended beyond just the mums, and now the father or the partner of the pregnant woman is also entitled to attend 2 antenatal appointments of up to 6.5 hours each. This is unpaid time off, and the individual has to demonstrate they have a qualifying relationship with the pregnant lady to be able to get it. A qualifying relationship is either her husband or civil partner, and that's regardless of whether the child is theirs, or they live with the mother but they're not a relative, so it couldn't be a grandparent, for instance. It would have to be someone who lives with the mother but's not a relative. Or the third qualifying relationship is where the child is theirs. So that's of course meant to cover someone who's broken up with the mum, but the child is their child. The employer does have the right to refuse to allow the employee the time off in this case, however, only if it's reasonable to refuse. I think the sorts of scenario that refusal will cover will be where Perhaps the employee is financial controller or accountant for the business, and the accounts are being filed and he's requested or she's requested the time off on the last day for filing, and there's absolutely no way that the employer could accommodate it. But I think in that kind of scenario, I would advise my clients that although they might refuse that particular time off, they should be offering an alternative and thinking of a compromise. So, okay, we can't offer you Wednesday off, but could you have Friday, for example? Another new concept is going to be introduced from the end of 2014. There is going to be a new health and work service offered, which is government funded. This is the concept that the government will fund occupational health provisions for employers after an employee has had 4 weeks off, or they are advised by their GP that they are going to have 4 weeks off. That GP will have to automatically refer the employee to occupational health for a review, and that review will be funded by the government. The idea behind the occupational health referral is that the occupational health provider should then advise on a return to work plan and provide access to a case manager to help manage the return to work and phase return to work. As I said, it's expected to be rolled out towards the end of 2014, and certainly we've been told before May 2015. However, it's starting to look a little bit tight now, given that we're already well into October. So I'd be quite surprised actually if they've got this up and running before the end of this year. I suspect it's going to be the beginning of next year. The government has confirmed that it has appointed the national provider, the occupational provider. It's a company called Health Management Limited. Now, one of the questions I have is that in principle, I think this sounds like a good idea, particularly for small employers that perhaps can't afford or do not have access to an occupational health provider. But my concern is most of the clients that I work with have occupational health providers that are perhaps tailored to their sector, experts in their sector. For example, in the construction industry, they'll have an occupational health therapist who's very attuned to the demands on a construction worker. Or in the schools or education sector, again, an occupational health provider that knows the demands on a teacher. And my concern is that if we've got a national health, occupational health provider, Health Management Limited, that everyone is automatically referred to, how tailored is their advice going to be? And if it's not particularly well tailored to the industry, is the employer then allowed to take separate advice from its own occupational health provider, more expert specialist advice? I suspect that they will be able to. There shouldn't be anything stopping that happening. But then if you get 2 contradictory reports, perhaps you get an occupational health provider that says that the employee is ready to return to work and another occupational health provider that says that they're not, which one takes priority and who determines that? So that's my concern, and I think until we see this process up and running, it's not going to become clear what the answers are to those questions. Just moving on to the next slide. Now this is a big topic at the moment that I know a lot of you will already be very familiar with. Essentially, under the Working Time Regulations 1998, employees in the UK are entitled to 5.6 weeks holiday. During that holiday, they are entitled to a week's pay for each week of holiday that they take off. Under sections 221 to 224 of the Employment Rights Act, the legislation determines how a week's pay is calculated. And it states that if the worker's hours vary week to week, then it is to be calculated by averaging the pay over the 12-week reference period before they go off on holiday. This is very well accepted legislation and has been applied by many employers for since 1998. But the problem that's recently arisen in the cases named on the slide is that most employers, or many employers, were not taking into account non-guaranteed overtime, on-call payments, standby payments and commission payments because they are not included within the employee or the worker's basic pay. That's just something they get over and above that. We then had a case called Neil and Freightliner, which determined that non-guaranteed overtime pay should be included when averaging the pay over the 12-week reference period. In addition, in the case of Fulton and Bear Scotland Limited, it was determined that overtime payments, on-call payments and standby payments, i.e. the ones an employee might receive for remaining at home but having their mobile phone turned on waiting for a call, should also be included within the holiday pay. Then we got a case called Locke and British Gas, and it was decided that commission should also be taken into account. So that's not guaranteed pay, but commission that is earned during the 12-week reference period should be included when calculating holiday pay. Some of those cases were appealed, and the appeal hearings were heard in summer this year, but we've not yet got an outcome to that appeal. We were expecting to get it by the end of October and not yet received it. But to be honest, even if the appeal is successful, I suspect it will be appealed again up to the next level of court and perhaps even up to Europe. And it may not be until next year or even the following year that we get a final determined decision on this point. At the moment, though, it's looking like the decision may be that the non-guaranteed overtime pay, commission, etc. should be included within holiday pay. So you might now be asking yourselves which companies are going to be affected by this. Effectively, it's going to be any companies that pay a lot of overtime, call-out, standby pay, where employees can earn a lot of commission or work-related allowances, and that at the moment those payments are not being taken into account when calculating the holiday pay. So I suggest what you do is assess if this is likely to be a problem for you. The next stage then is to decide whether to take the wait and see approach, which is to wait and see what the outcome of these cases are. As I said, it could be another 12 months, 18 months, even 2 years before we get a final determined decision on this. Most of our clients are taking that approach to wait and see. The alternative is you could act now and change your holiday pay policy going forward. You could decide from today we are going to include guaranteed overtime, non-guaranteed overtime, commission payments, call-out payments, etc. within the holiday pay calculation, which will of course increase employees' holiday pay going forward. That rectifies the holiday pay issue going forward. What it doesn't do is rectify it historically going backwards. And the risk is that you could, by changing the policy now, crystallise historic claims and alert employees and their trade unions to the fact that you've just crystallised the holiday pay claim. What I mean by this is that in most cases employees have 3 months to bring a claim against their employer. If you change the policy going forward, an employee would need to bring the claims now for the holiday pay in order to not lose their ability to do so. Because if they didn't bring the claim, 3 months passed, they could then become barred from bringing that claim unless they brought it under a different jurisdiction, such as in the civil courts. So most clients, as I said, are taking the approach to wait and see and wait to the outcome of those cases. It is a difficult point. It could be very costly for some companies. On the flip side, though, the employees will have to demonstrate quite a number of evidential factors in order to bring this claim successfully, and I would be quite surprised if many employees have recorded how much holiday they have taken since 1998 and how much commission and overtime, etc. they had been working in advance of that. So I think employees will find it quite difficult to demonstrate that they should have received an increased payment. Moving on to the next slide. I've now finished on the legislation. I'm just going to go through some of the recent cases that are quite interesting. This first set of cases is about terms of the employment contract that can be implied into the contract by way of custom and practice. Just by way of explanation, there are 2 different types of term included employment contracts. One is express terms. Those are things that are written in the contract. Then there's also implied terms, which are ones that are not written down on the contract but can become enforceable against the employer or the employee by way of custom and practice because they're always relied on. Just to demonstrate this, the first case, Peacock Stores. Peacock is the fashion store that sells ladies' clothing. They had operated a consistent practice between the early 1980s and 2002 of offering enhanced redundancy pay, and they had consistently lifted the weekly cap on pay and also the cap on the length of service when calculating redundancy pay. And as a result, employees were receiving much higher redundancy payments than statutory payment. They made another redundancy in 2006 and applied the same consistent practice. There was then a gap of 6 years until 2012. And in 2012, they didn't enhance the redundancy payment. They just paid statutory payments. The employees then brought claims and said that's not fair. Okay, there may not be an express provision in our contracts entitling us to enhanced redundancy pay, but you've consistently applied this practice. And the EAT confirmed, the Employment Appeal Tribunal confirmed that that's correct. Because Peacock Stores had consistently applied a practice of enhancing payments, redundancy payments, then the enhanced redundancy payment should apply to 2012 as well. Even though there'd been a gap of 6 years, there was no evidence to demonstrate that in those 6 years the practice had been varied or superseded. So it's just a bit of a cautionary tale that if you start to be more generous in certain redundancy procedures, I think that's fine. You've just got to make it very clear, perhaps in writing, that this is a one-off discretionary payment and it isn't intended to create a custom or practice or an implied term. In CSC Computer Sciences, there was a cheapy transfer of employees from an IT company to CSC. 200 employees cheapy transferred across. And for those of you that are familiar with cheapy, this means that they transfer on their existing terms and conditions. In their employment contracts, it stated that they were entitled to a salary review on an annual basis, but there was no guaranteed increase mentioned. However, when they cheapied across to CSC, CSC had the mistaken belief that they were entitled to an increase in line with the RPI. So as a result, in 2008, they made an increase to the employees' salaries in line with RPI based on that mistaken belief. And they did so again in 2009. But then subsequently in 2010, they realised that this had been based on a mistaken belief, and in actual fact the employees were not entitled to the RPI increase, so they didn't do it. 23 employees raised grievances and brought employment claims. They said, even though this was a mistaken belief, you have now created a custom and practice, and as a result, we are entitled to the RPI increase each year. And the Court of Appeal upheld this claim in this case and confirmed that it didn't matter that the employer's understanding was mistaken because they had conveyed a consistent message since the cheapy transfer that they were entitled to enhanced salary reviews, so linked to RPI. They'd created a custom and practice, and as a result it formed part of their contract. Just moving on to a slightly different point here, it's important to note that if the employees have an express term in their contract that states that perhaps they're not entitled to something, the fact that the employer then, by custom and practice, continues to give that employee some entitlement or benefit does not override the express term that says in writing they're not entitled to it. This is because in law an implied term can't override an express one. So in the cases that we've just seen, if there had been an express term in the first case about the redundancy payments, so the Peacock Stores case, saying that the employees were not entitled to enhanced redundancy, the fact that an employer had consistently given them enhanced redundancy can't then override that express term, which is really important because it then means it's important to get the contracts right in order to protect the employer. This was demonstrated in the case Vision Events and Patterson. In this case, the claimant was employed as an events technician, and the company had a flexi hours scheme, which meant that if he worked extra hours, he could take them off in lieu. However, the policy did not state anything about what happened on termination of employment. The express provision in the policy was that if you work extra hours, you must take those hours off in lieu. The employee was made redundant and said that he was entitled to be paid in lieu of hours still owed to him, and the employer refused. He obviously brought a claim saying that he was owed salary for the flexi hours that he'd worked, the extra flexi hours he'd worked. And the Employment Appeals Tribunal, in this case, helpfully confirmed that there was no such express term in the contract entitling him to payment in lieu. All it said was that he was entitled to time off in lieu. And in light of this, he should have taken the time off during his notice period. That's how he would have got the benefit back from having worked extra hours. It didn't entitle him to pay. So that's quite a helpful case there. Another practical point is in relation to this Hershaw and others case. This is around whether an HR consultant can bind an employer to a contractual change or a variation of the employment contract. In this case, the claimants were market patrol officers for the council, and following a review of their pay or grading structure, the council sought to vary the employees' pay. The claimants or the employees complained and raised grievances. The council subsequently got an HR consultant, an external HR consultant, to consider the grievances because they felt she was going to be entirely independent. And she gave the outcome of the grievance in January 2012. She wrote to each of the employees to confirm that they should have been moved from a grade 3 onto a grade 5 on the pay scale. And this would have resulted in quite significant salary increases. I think it took them from 16,000 to roughly 19,000 per annum. So it's quite a big jump for these employees. The council had an appeal, and the appeal panel considered the matter and overturned the decision, saying that the HR consultant had mistakenly interpreted the pay grading structure, and as a result they retracted the salary increases. Now, the claimants or the employees brought claims to the Employment Tribunal saying that this wasn't fair, and actually the letter that had been received from the consultant, the HR consultant, had bound the council to increase the salaries. The employer, so the council, said the HR consultant was brought in specifically to hear the grievance and did not have the authority in this case to increase salaries. Interestingly, the Employment Appeals Tribunal confirmed that the HR consultant's letter did create a binding contractual commitment to increase the salary, and it didn't matter that she did not have the authority to do so. So this is just a note of caution that if you're using HR consultants, I think it's important to be very clear on what authority they have, and also to make sure that they fully understand, for example, in this case, your pay grading structure. I think this case wouldn't have resulted if there had been clear communication between the council and the HR consultant on A, how the pay grading structure worked, and B, what she had authority to do. Now, finally, before I hand over to Tim, I'm just going to cover a few cases on discrimination. The first one you may have seen on the news recently is the Coltoft case, and this is about whether obesity is a disability. In this case, there was a childminder who worked for the municipality of Billund in Denmark, so this is not a UK case, which is why it's got that funny reference number at the end of it. He had a BMI of 54, so I understand he was quite a large gentleman, and he was dismissed after 15 years service with his employer, and he alleged it was due to a disability, which he said was obesity. Now, the Danish court referred the question as to whether obesity in itself was a disability to the European Court of Justice. And in the European Court of Justice, the Advocate General confirmed that obesity is not in itself a disability, but certain conditions may be so if they satisfied the national definition of a disability. So essentially, obesity is not automatically a disability, but you need to go back to the question in your own UK law as to what is a disability or not to be able to determine whether in that particular case it could be. And just to remind you, the question in the Equality Act 2010 is, does that person have a physical or mental impairment that has substantial and long-term adverse effect on their ability to carry out day-to-day activities? So you can see how some cases obesity may satisfy that question, whereas in some it may not. And it is a very difficult point that we often get asked about, could this condition amount to a disability or not? And generally speaking, you need to get medical advice from an expert. Moving on to the second case on this slide, Ling, which is the Employment Appeals Tribunal case. This is about what evidence is needed to demonstrate someone is disabled when a tribunal claim is brought. Ling was a janitor who went off sick in February 2012 for stress and depression and was subsequently dismissed in October 2012. Now, she brought a claim for disability discrimination. And for those of you that have had cases go through the tribunal procedure, you may remember that there is a preliminary stage where the employment tribunal can consider whether the employee is disabled or not, and that's called a preliminary hearing. And at the preliminary hearing, they're not considering all of the facts of the case, they're just considering is this employee disabled or not based on the evidence that's put before us. And as it happened in this case, the only evidence that was put forward was the GP records about this lady's stress and depression. And initially the Employment Tribunal ordered that it couldn't proceed on the GP records alone in determining whether the employee was disabled, because perhaps that GP hadn't written very much about the stress and depression. It hadn't given many examples of how it was impacting on her life. So that tribunal ordered the parties to go away and to get an expert report, which would probably be a psychiatrist, to determine whether the employee was stressed and depressed and indeed disabled under the Equality Act. That tribunal ordered that the employer should pay for the expert report. In this case, City Facilities Management were not happy with that, and they appealed to the Employment Appeals Tribunal purely on that point. They said, it's not for us to have to prove whether she's disabled or not. She chose to bring this claim. And the Employment Appeal Tribunal confirmed that as correct. It said the burden of proof is on the employee to establish whether she is disabled or not. It's not for the Employment Tribunal to proactively seek additional evidence. And therefore it would be wrong for the tribunal to order the employer to go away and pay for a psychiatric expert report. So it sent the matter back to the tribunal to be heard in full. I don't know what the eventual outcome is as to whether she was disabled or not, but it's quite interesting and helpful for employers. Although I have to say, my advice to clients is that it is still helpful to get as much evidence as possible, medical evidence, in advance of going to tribunal, because there's too much of a risk just going on the GP records alone. And if there is a question mark over whether someone's disabled or not, it's usually safer to assume that they are, and then to go and make the reasonable adjustments or whatever else you might be doing to support that employee, because you're going to reduce the risk of a successful disability claim against you if you just assume they're disabled and therefore make the adjustments to accommodate them. Moving on to the next slide about what is a reasonable adjustment. These cases are reasonably quick. In Fuller, the employee had asthma and another lung condition, and in this case the employer had to keep the windows open in winter for the other employees because the office was very, very stuffy. It did place the employee with asthma at a disadvantage because of the cold air that was coming in through the windows. And she brought a claim against the employer saying that they'd failed to make reasonable adjustments by leaving the windows open. And in this case, helpfully, the Employment Appeal Tribunal said no, the employer had still complied with its duty to make reasonable adjustments, and that the employer is quite right to take into consideration the impact on all the other employees in the office. So it was right to think about all the other employees that were complaining that the office was stuffy. Now, just a word of caution on this case, though, is I think the tribunal and the Employment Appeals Tribunal did have more sympathy with the employer here because it had attempted other reasonable adjustments that had not worked. So I think it had tried to move the employee around the different positions in the office. I think it had offered that she could work at home, and she'd either refused some of those adjustments or they'd not worked. So the employer had been quite reasonable in trying other things. It didn't just refuse to shut the windows. There were other circumstances and background facts behind this case. Now, the second case on this slide's got quite a funny name. Mrs. Butcher worked for Croft Vets. She was a receptionist and office manager. She was very stressed and depressed, and it was work-related stress. She was referred to an occupational health therapist, and that was a chap called Dr. Parry, who recommended that she should get private counselling and psychiatric sessions, which should be paid for by the vets. She was subsequently dismissed for different reasons and brought a reasonable adjustment claim or disability discrimination claim against Croft Vet, saying they had failed to pay for the private counselling and psychiatric sessions. In this case, the court, which was the Employment Appeals Tribunal, upheld her claim, found it was successful, and they had failed to make reasonable adjustments by refusing to pay for the private counselling. Now, I have to say that's quite an onerous and high level of adjustment that has been expected of the employer here. I was quite surprised when I read this case initially, but if you delve into the facts a little bit more, this lady was extremely stressed and depressed because of the level of workload that was being placed on her by the vets, and that really had I think a big that was a big factor in the decision that was finally made in this case. I think the tribunal and the Employment Appeals Tribunal didn't look favourably on the employer from the very beginning because of how much work it had placed on this employee. So when the doctor had ordered that a private psychiatric and counselling session should be paid for by the employer, that was against a backdrop of that employer having already created the stress and depression. Now finally, before I hand over to Tim, just to cover a couple of other reasonable adjustments claims. London Borough and Southwark against Charles. This is an employee who was an environmental enforcement officer who in March 2011 was put at risk of redundancy. Very quickly after being put at risk in May, he was diagnosed with sleep paralysis and depression, and an occupational health advisor told the employer, the council, that he couldn't attend any administrative meetings because of his disability. He was then told by his employer, the council, that he needed to go to an interview for alternative posts during the redundancy process. He said he couldn't attend because he was depressed, and that the occupational health therapist had said he couldn't go to any meetings. As a result, he didn't attend and he was dismissed by reason of redundancy. He brought a claim for failure to make reasonable adjustments against the council, and this was successful. The Employment Appeal Tribunal said he should have been offered alternative ways of assessment as a result of the advice from the occupational health therapist. For example, they should have done a scoring system, perhaps based on previous PDRs. I don't know exactly what the outcome of this case was in terms of award. That's because the Employment Appeal Tribunal then referred this case back to the tribunal to consider whether there should, or how much the remedy should be, so what award, what compensation should be paid to the employee. And the only thing I should point out here is, although on the substantive case the employer lost and it was found that they failed to make reasonable adjustments, the award or compensation that was given to the employee may have been reduced significantly if, for example, it was found that even if they'd used a scoring system to score this employee, they still wouldn't have got the suitable alternative job, and they still would have been dismissed. So it's a helpful case to think about alternative ways of interviewing people, but I don't necessarily know whether any compensation was paid to this employee. Finally, in relation to Haworth and North Lanarkshire teaching North Lancashire, this is a very sad case involving a health visitor who was diagnosed with breast cancer and had a series of other problems at home. I think her best friend was very poorly and her son as well. So she was suffering not only from the cancer, but I think she was also stressed and depressed. She then committed theft and battery at a supermarket. I think she stole goods from the supermarket, walked out, and then when the security guards tried to stop her, she pushed through them, hence why there was also the battery allegation against her. And she was dismissed by the PCT, and she subsequently brought a claim for unfair dismissal, but also failure to make reasonable adjustments, so the disability discrimination claim. Now, initially at the Employment Tribunal, they found that there had been a breach of the duty to make reasonable adjustments, but the Employment Tribunal didn't specifically identify any single adjustment that could have actually meant that this woman would have kept her job. So it was appealed to the Employment Appeal Tribunal, who said, actually, although this is a very, very sad set of facts, and we can understand why there's sympathy with this lady, because clearly when she committed theft and battery, she was going through a very difficult time in her life. That may be the case, but it doesn't automatically follow that she has a successful disability discrimination claim for failure to make reasonable adjustments. The Employment Appeal Tribunal said what the tribunal should have done is look to see what reasonable adjustments could have been made to ensure that she kept her job. And it failed to do that. It failed to identify any adjustment that could have been made to help her stay in her job. And as a result, the claim was overturned. I'm now going to hand over to Tim to start on the next slide.
Thank you, Francis. The next slide picks up on a point around medical reports. It's one of the things that we struggle most with when we're advising clients is in relation to long-term sickness absence. There's an uncertainty about when it's always safe to dismiss. The issue in this particular case was whether or not Mr. Gallop could pursue a disability discrimination claim following a period of absence and some misconduct which led to his dismissal. The claim was allowed to proceed despite the fact that the council said it had no knowledge of any disability. This was even though the council had obtained a number of medical reports during the period of absence prior to the dismissal itself. The council was told by the Court of Appeal that what they should have done with the medical report was not to have unquestionably accepted the report it received. The Court of Appeal suggested, for example, that a reasonable employer should form its own opinion as to the disability and not simply rubber stamp the report that was obtained from the occupational health providers. The lesson therefore for us is that we should ask specific questions of any occupational health report which we receive or any doctor's report which we receive, and then we should make our own opinions as to whether or not that individual is disabled. Just one more case in relation to long-term sickness absence. The facts in BS and Dundee City Council are nothing remarkable. They're commonly seen where an employee has been on long-term sickness absence, and the question is eventually asked by an employer, when is it safe to dismiss? Can we dismiss and can we be confident that there'll be no comeback on us? The test which this particular case tries to establish for us is whether or not it is reasonable for an employer to wait any longer. So following a period of consultation with the employee, following the receipt of all the necessary occupational health reports, can the employer or should the employer wait any longer before it dismisses? The Court of Sessions in Scotland suggested that this was going to be an issue of balancing. We had to balance up the needs of the organisation in question, the size of the organisation in question, whether or not the role of the individual being performed could be vacant ongoing, and whether or not there was cover which could be easily obtained without any additional cost to the employer. Also, if we'd exhausted sick pay, that may also be something which may determine the reasonableness of a dismissal on the grounds of long-term sickness absence. Moving on to a couple of slides around discrimination. The first is in relation to sex and maternity discrimination, and we've listed there two cases on the slide. And the question is, which one of those do you think is discriminatory? The answer is actually the Commissioner of Police case. Here, a police dog was removed from their dog handler because of their pregnancy. This was considered to be a disadvantage suffered by the police dog handler, and the only reason why the dog was removed was purely because of the pregnancy itself. The police said that they wanted to keep the dog in operation, and so therefore to take it out of operations would mean that the dog had less effect in the future. On the other hand, the case in Lyons v DWP Job Centre Plus is slightly more tricky to get your head around. This was a dismissal for absence due to postnatal depression. Clearly, it was accepted that the reason the employee had been treated unfairly was because of her pregnancy-related illness. But an employee can only bring a claim for this sort of discrimination if it's within what is known as a protected period. The protected period is the period of the pregnancy and the maternity leave itself. And in this particular case, she fell outside of that period, and so therefore her dismissal was not considered to be on the grounds of her maternity or her sex. In effect, she was treated no differently to any other man in a similar situation who would have been off work for long-term sickness absence. Over the course of this year, there have been a number of cases which relate to constructive dismissal, which is something which we hear much about as employment lawyers, but is also something which is much understood by employers and employees alike. We've picked out one particular case which I think is of interest to any employer, and that is the case of Atkinson and the Community Gateway Association. The question which was answered by this case is whether an employee who might be dismissed for gross misconduct, whether or not they could resign and claim constructive dismissal first, i.e. can the employee jump before they're pushed? In this particular case, the EAT said, yeah, they can. The obligation, or the trust and confidence obligation, which is owed by all parties in an employment contract at all times, carries on even if the employee has breached that obligation first. The idea, therefore, is that the employer must continue to honour the contract regardless of what has happened prior to the stage of dismissal. The next couple of slides look at issues in relation to dismissal. The first slide here, it looks at the reasons for dismissal. If there was ever a teacher stuck between a rock and a hard place, it was probably the head teacher in this particular case of ZVA. The issue was that the head teacher had learnt of allegations around the caretaker. The allegations were historic. They had yet to be proved. The police were being very, very circumspect about what they said about the allegations. And the allegations themselves, we understood, related to child sex offences. The head teacher had to decide whether or not she should dismiss this caretaker. She decided that she would, and the ground for dismissal was some other substantial fair reason. There was no conduct which the head teacher could dismiss for, because all the conduct related to issues way before the contract of employment came about. However, the EAT had concerns about this and said that a bare accusation was not enough to dismiss. In short, we had to be more reasonable about going around dismissal situations where all we had was an accusation of improper conduct. In a slightly different case, which went to the Court of Sessions in Scotland, the CJD and RBS case, this was a situation where the employee was dismissed. It followed a domestic incident between the employee and his girlfriend, who was also an employee of the bank. The bank found out about that domestic incident where it was alleged that the male had assaulted the female. However, the defence put forward by the male employee was that he was acting in self-defence, and the person who made the decision to dismiss accepted that defence and believed the male. Because of that fact, that decision to dismiss the male employee was considered to be unfair. The Bank of Scotland could not show that it reasonably believed in the guilt of the male employee. And although the incident may have been a bit unpalatable, the dismissal could not be fair because there was not a reasonable belief. Moving on to procedural aspects around unfair dismissal, we flagged one particular case here concerning Marks and Spencer. The individual in this case was dismissed for certain action which was entirely inappropriate. The individual was fraudulent using their store card. However, prior to the dismissal, the claimant had a number of other issues ongoing, which had resulted in a final written warning being issued by Marks and Spencer. And the question which the Court of Appeal considered in this case was whether or not the tribunal can look behind previous warnings which had been given to the employee. Now, the answer to that question is yes, a tribunal can, but there's a limit to it. A tribunal can only establish the prima facie grounds of any previous warnings given and make sure that those warnings were given in good faith. What a tribunal cannot do is re-examine the facts of any particular warning given and whether or not that warning was reasonable in the circumstances. The lesson, therefore, from this case is that we must continue to take care at any disciplinary stage, not just at the final stage of dismissal. Now, it's quite common, particularly in smaller organisations, for disciplinary action to be dealt with by external third parties, often HR consultants, for example. And we've got two cases here. The first is GM Packaging, the second is Kasoka, which determine whether or not it is reasonable to use HR consultants. In GM Packaging, the managing director had learnt of an affair between two staff and had asked an HR consultant to do the disciplinary process as well as the appeal. That was considered to be a fair procedure for the purposes of unfair dismissal. And so therefore, it gives a little bit of credibility, if you like, to smaller organizations using HR consultants with a bit of confidence. The Kasoka case is slightly different, and we probably need to stress that it is fact sensitive. But on this particular case, a managing director of a day nursery had made the decision to dismiss the claimant. The claimant appealed, and so the managing director had asked an external appeal panel to consider whether or not the dismissal should be upheld. The appeal panel felt that there wasn't enough evidence to uphold the dismissal, but the managing director ignored the advice of the appeal panel and said, no, we're still going to dismiss. I still think there's enough evidence. That was also considered to be reasonable in the circumstances. But we must stress that what is reasonable is often fact sensitive. It is based on the size and the administrative resources of any particular employer. And clearly one case can't always be applied to another because each case is different on its facts. Another case which looks at procedural fairness and procedural issues is the case of Macmillan v Airedale NHS Foundation Trust. The question here was whether or not it is ever reasonable to uplift a decision on appeal. In this particular case, the appeal had decided that actually maybe the decision to issue a final written warning was insufficient and that in fact the claimant should have been dismissed. But here the Court of Appeal said that we can't uplift a decision on an appeal. The appeal is for the employee's benefit, not for the employer. However, the Court of Appeal did suggest that it may be foreseeable if one reserves the contractual right in a contractual disciplinary policy to uplift the sanction. But this really sits uncomfortably with me as a lawyer. I think it presents lots of further challenges and problems. At the very least, if you were to have that right, you would need to afford the individual another right to appeal. And I think this gets really, really messy and would be ill-advised. So that's it for our Muckle Employment Team update. We hope you found the content helpful. If you have any questions, feel free to call us. You've got our details. And there are other ways to stay in touch with us and to stay up to date. Further information can be found on the slide. There we have a LinkedIn group, for example, and we also send out regular newsletters and updates via the LinkedIn group. And there are details, and thank you very much for listening.